Hi, this is Barry Chase, the senior partner of ChaseLawyers, and today we're going to talk about the ins and outs of trademarks. Okay, everybody, so today we're going to talk about trademarks, and trademarks are not copyrights. Copyrights are for original works of authorship. We're not going to talk about patents, which are usually for inventions. We're going to talk about trademarks, which are usually a short phrase, a word, can be a shape, can be a color even, that identifies the source of something, whether it's a product or a service. So that's what we're going to talk about. It's basically about a brand. So what is a trademark, actually? Now, we know it's not a patent, it's not a copyright, it's a brand name. Think Coca-Cola, for example. When you order a Coke or a Coca-Cola, you're ordering it because you like that particular brand and you want to have something from that source, not from Pepsi. So those things guide a consumer to what the source of the product or service might be. And they suggest something about the quality of it. They suggest something about the taste of it, the color of it, what have you. That's what a trademark is about. It tells us as consumers, where's this coming from anyway? Okay, so you might ask yourself as a civilian consumer, why do we need to have this legal structure involved with enforcing trademarks? And the answer is to avoid confusing people who might want to buy a product or service. For example, if we had two kinds of soft drinks, and one is spelled K-O-K-A, K-O-L-A, and the other is spelled C-O-C-A, C-O-L-A, and I order a Coca-Cola, which one am I going to get? I'll be confused, and I won't know which one I'm actually getting. So it is to avoid things like that. You could not get a brand name and something that sounds just like Coca-Cola, even if you spelled it differently, because that would mislead consumers about what they were actually getting when they bought that brand. So that's the basic point. It's to tell you where the product that you're interested in actually comes from and to assure you that it's the same place that made the product that you enjoyed so much last time. So you might ask yourself, how do you protect your brand through trademark law? And the answer is the first of our surprising little factoids that I want you to take with you when you finish watching this video. And that is that you don't get protection by just registering. You get protection by using it. You get protection by being the senior user of your mark in your line of products or services. For example, we have a trademark at ChaseLawyers, a registered federal trademark in the name ChaseLawyers with a capital C and a capital L. That means that we were the first to use that mark in connection with legal services. But it's the use of the mark that gives you the rights. When you go to the trademark office, which we'll get to a little later in this video, and try to apply for a federal registration for your mark, one of the things you're going to find out is that you won't get a registration unless you can show the trademark office that you've been using the mark. That is the key. In our system, it is not registering that gives you trademark rights. It is using it. So right from the get-go, you should begin to use whatever your brand name is. And the second little surprising factoid is that without anyone else's permission, mine, the government's, the president's, anybody's permission, you can use that little TM symbol that you see to the sort of the northeast of a lot of brand names. Pick up something that's got a brand name on it, and you'll see either an R in a circle if it's a registered mark, which yours isn't yet, or a little TM, no circle, but a little TM, which means trademark, which all that means is that you're claiming trademark rights in this. It doesn't mean anybody has said you've got them. It just means that's your claim. And you can do that without asking anybody. and without paying anybody a dime. So now you have two very valuable new pieces of information. You got to use your trademark, and you should use it with that little TM in the upper right-hand corner just after the mark. Now, the first thing you want to do in using your brand name is to make sure that it's not already being used by someone else as a trademark. And you can do that with what we often call a poor man's search, which won't cost you a nickel. You Google the name, see who's using it. If anybody is using it in an area that's like your product or service, you may run into trouble and you may not be the senior user. So you might want to dispense with that brand name and go to choice number 2. You also, as a poor man's search, can go to the uspto.gov website. That stands for United States Patent and Trademark Office. And you can do a search there in the Trademark Office branch of that to see whether anybody has applied for a federally registered mark or actually has a registration for a similar mark. Now, if you get good news on those searches, that is, you don't run into somebody who wants to use your first or second choice as a brand name, you should start using it like mad and use it with that little TM that I mentioned earlier in this, in the top right-hand corner. Use it early and often, as they say about voting, and you will establish eventually that this is the brand name for your product or service. Now, we often get the question at ChaseLawyers about whether a trademark can be a logo design, for example, a piece of artwork or what have you. And the answer is yes. A trademark can be a phrase, can be a slogan, it can be a picture all by itself, it can be a word or words, it can even be a shape, like the Coke bottle shape is a trademark. It's owned by Coke. You can't sell a soft drink in that shape bottle because it will be confusing to consumers. You even can get a trademark in aspects of color. There's a recent famous case where a very snooty French shoe designer named Louboutin won a trademark infringement suit because he uses a certain red color for the soles of his $1,000 shoes. And he won that just on the basis of the color. The same, for example, with the golden arches. You can't have a restaurant with golden arches because it will be unacceptably confusing to possible consumers of hamburgers. So yes, it can be a logo design, although let me leave you with this warning. You are best advised to use regular standard characters, which means just regular words, because if you're going to use words, you have the broadest kind of protection. It means anybody who wants to use those two words, whether in a logo, whether in a different kind of picture from yours, whether in a different color, is restricted from using them because you already own those words as your brand name. So think about, contrary to conventional wisdom, think about using just regular, what the Trademark Office calls standard characters for your brand name. Well, the answer, as it often is in the law, is not quite. Yes and no. If you have, for example, the name Acme for your skincare company, and your products are known as Acme Sun Lotion, Acme Concealer, or what have you, it doesn't mean that someone can't use Acme for a shoe company. Because remember, the purpose of all this is to avoid confusion on the part of consumers. Someone who's looking for a skin lotion is not going to be confused as to whether it's a skin lotion or a shoe company that I should do business with. So that as long as they are in different market segments, the same name, the same brand name can be used for different brands of different classes of goods or services. Now, you might ask whether you need a physical product in order to get a a brand name that's protected by trademark law? And the answer is no, you don't. Services, entertainment services, legal services, accounting services, all of those kinds of services are also subject to the trademark statutes. And so therefore, you have things like Lady Gaga as a brand name. Obviously, that's not the lady's actual name, but that has been established as the brand for that particular performer. And you can depend on that brand name when you buy a concert ticket. You're not going to get something other than Lady Gaga. And you need to depend on that in order to shell out your money, a lot of money usually, for a concert ticket to a Lady Gaga concert. So as any kind of service provider, you are also eligible for a trademark, which actually formally is called a service mark. But a lot of people like to talk about the whole category as trademarks. So you can use an SM instead of a TM in the upper right-hand corner. I don't usually advise it because SM also means sadomasochism, and some people don't want to be associated with that. So you can just stay with TM, and no one's going to invalidate what you're doing because you've done that, even though you're providing a service, not a product. Well, the short answer to this question is really no, because as we've discussed, you gain rights, you gain legal rights in your brand name by using it. And that you can do without applying for a federal registration. Nevertheless, if you do get a federal registration, you'll have certain advantages in the unlikely event of litigation over the trademark, over who really has the right to it. You'll get your attorney fees paid for if you have a federal registration, and you won't if you don't. So that's a big deal. And it also will scare away other people. Remember, back when we were talking about what you should do, we talked about a search, poor man's search, a Google search, and very importantly, a search on the Trademark Office website. Now, once you've applied for a federal registration, your application will be listed on the uspto.gov website. And so when someone applies, when someone rather searches about whether the brand is available, they will run into it if you're already applied for a federal mark. In the meantime, however, I want to stress again that you should use that little TM in the upper right corner every time you use it. Again, you don't have to be registered. You don't have to get anybody's permission to do that. And it has the great effect of scaring off people who might want to use a similar mark when they see that little TM, either because they're confused about whether that means you're registered or not, or they just see it and realize, well, somebody else is using this as a trademark, a TM. So it's very important that you continue to do that even as your application for a federal registration is being considered by you, when you're saving up money for it, or even after you've made the application, but before you have a registration. Okay, you can actually apply yourself at uspto.gov. The forms are available. The cost to file, the government fee, is only $250 per class, and we'll get to that in just a moment. But it's $250. Now, the problem is that you may not do it correctly, or you may be caught up in some of the lingo that the Trademark Office uses. For example, if they want to reach you, they'll send you something that's called an office action, and they can be very intimidating because they'll refer to all kinds of things in the trademark manual of this and that. So it is advisable, not required, but advisable for you to have an attorney who knows what he or she is doing. Go ahead and do this, even though there'll be a charge of something like $1,000 for the attorney's time in doing so. So I recommend that you do it through an attorney. But you can try it yourself and see whether you think that's something you can do on your own. Now, talking about the classes you should file in. If, for example, you are a musical artist and you want to apply for a brand name, for your brand name to be registered federally for your live performances, that's perfectly available. But you may also be selling t-shirts. You may also be selling a line of cologne or jewelry or what have you under your brand name. Again, think Beyonce, think Lady Gaga. They've all gone into areas other than the main sort of primary area of musical entertainment. Each one of those extra classes, though, the t-shirts, the jewelry, etc., will require yet another $250 application fee because they're treated really as separate applications. One for jewelry, the one you've already got for live performances in music, etc. So just keep that in mind as well. Now, before you say, well, my God, I don't want to spend all this kind of money, I just ask you to consider for a moment how valuable a trademark can be. Think, quote, Mickey Mouse. Now, if you owned that mark and therefore you could receive license fees for watches and toys and books and all kinds of other things under the Mickey Mouse brand, you'd be a pretty rich person within a month or two. So think about how valuable a mark can become. Coca-Cola, Mercedes, Chevy, etc. Marks can become extremely valuable, and yours might be too down the road. So keep that in mind when thinking about, well, gee, should I really throw a four-figure amount at my brand name? Okay, so what happens actually when you file your application or your lawyer files an application for you for establishing your brand as a federally registered trademark? Now, the first thing that happens is you'll get a receipt that shows that your application has been filed. Your lawyer should be sending you a copy of that because you want those for your company files. Remember again, this could become, it might be already, a very valuable brand name. So you want to make sure you got the paper trail. You can keep it obviously digitally and not on physical paper, but you want to make sure you've got that paper trail for your ownership of the federal registration from the application forward. Now, after you get that receipt, and this often is a problem for a lot of my clients, you'll hear nothing for 4 to 6 months. There'll be a backup at the trademark office, during which time applications will stand in line and eventually be assigned to someone called an examining attorney or an examiner, who will look to see, well, are there any conflicting marks? Are there senior users for this mark or something that could be confusingly similar? And eventually, if questions are raised like that, then you'll receive something called a, quote, office action, which I referred to before, that you'll have to respond to from the examining attorney. Now, if things go smoothly, which they do in about 50 to 75% of the cases in my experience, depending on how well you explain your situation to your lawyer and how well your lawyer does in filing the application, it will still take you at least 10 months, usually a year, before you actually get to the point where you receive a registration certificate. Now, the registration certificates are fun because they're sort of formal, although the trademark office is considering getting rid of all paper documents, so you may just have this in a digital file. But be that as it may, it's sort of a neat thing to get back from the government. It's got a seal on it and all that. You'll see an example of it, which we've embedded in this video. Once you receive that, though, you immediately want to change all those TMs you've been using to the R in a circle, because you do want to demonstrate that now I'm a federally registered mark. This means business. Don't you dare infringe it. And when you see it, you know that it means my brand. Now, when it comes to something called international trademarks, which really don't exist, the trademark office hasn't done us any favors. And the reason is that an international treaty set up, quote, what are called, quote, international classes of goods and services. so that you may be registered in international class 41, for example, which is education and entertainment, or international class 25, which is apparel. But it doesn't mean that you're actually internationally registered. To do that, you have to go jurisdiction by jurisdiction, so that if you want Europe, you have to get a European Union application. You can do that, though, immediately after you file your US application. Once it's pending, you can go out. You have to pay the same fees that anybody would for a European trademark, but you can use your US application as a basis for your application in Europe. These days, because the UK is opted out of the European Union, you have to get a separate one for the UK, although some of the old European trademarks were accepted in the UK as part of the Brexit thing. But in any event, you have to go jurisdiction by jurisdiction. If you want a Mexican trademark, you're going to have to go to the Mexican authorities and pay the extra fee for that. So your lawyer can guide you through what the fees will be for various markets that you want your brand to be recognized in. But just because something's called a, quote, international class doesn't mean you're protected internationally. Now, obviously, I've generalized and simplified some of what you've seen in this video. So if you have specific questions about your situation and your own status in terms of establishing your brand as a trademark, feel free to give me a call or contact me in any other way as indicated on the screen. And in the meantime, be sure to access and subscribe to our YouTube channel, which you can access by searching for ChaseLawyers once you're on YouTube. And you'll see a lot more information, some of it on trademarks, and a lot more information that may be of use to you in your intellectual property protection in general. And we'll see you next time on the next video when we get together to discuss some other fascinating topic.
So if you like this video, hit the thumbs up button below and let us know. Also, you can subscribe to the ChaseLawyers YouTube channel for more legal tips for those in the entertainment industry like yourself. And if you have other topics you want us to cover, please let us know in your comments below so that we can help you out in that way too. See you soon.